Okay, well, then, Mr. Beneficiary, take you and your trust back to jail. I ask the questions, you give the answers. Is that clear?
Mr. Beneficiary, you should not go into the court. I thank you very much. Thank you.
It is not fair. You cannot do this. Under oath and on record, you cannot do this.
If you're not Mr. Pollard, then you're not here to warrant for your arrest, and you can sit in jail till you rot for all I care.
That's fine, Your Honor, but that's...
Deputy, you can remove him. He's not here.
He's not here.
We're examining a contentious case today that involves a sovereign person who will be the subject of 4 court sessions. This individual has been questioning every judge they come across, and their actions are getting riskier. I won't get into all the specifics just yet, but it's obvious that they're breaking the rules that most of us abide by. Nonetheless, the judges are remaining composed and managing the matter effectively. In your opinion, what ought to happen to someone who behaves in this manner? Stay tuned as we continue to examine this case.
Okay. Beneficiary.
Oh, he's done this before.
What's his name?
The beneficiary.
You have a first name, Mr. Beneficiary?
Are you stating that the trust that we are administrating is the Kevin Pollard Trust? If so,
I'm asking what your name is.
My name is the beneficiary of the trust.
Of whose trust?
Are you stating that the trust that we are now administrating is the Kevin Pollard Trust, Your Honor?
Okay, I'm gonna recall him. Bring up somebody else. Put him aside. Put him at the end. Sir, is your name the beneficiary Kevin Theron Anthony Pollard? Yes or no?
I'm the beneficiary of the trust, Your Honor. Are you stating that the trust that we are now administrating is the Kevin Pollard Trust?
Are you Kevin Pollard? I'm asking you.
Is the trust that we are now administrating?
Sir, I ask the questions here. You give me yes or no answers.
You're asking for my permission.
I ask the questions. You give the answers. Is that clear?
It's very clear.
Okay, listen.
Yes.
Are you also known by the name of Kevin Pollard amongst other names? Yes or no?
Are you stating that the trust that we are now administrating is the Kevin Pollard Trust, Your Honor? If so, Kevin Pollard is in fact present today. It is you that is Kevin Pollard, Your Honor. It is you.
Really?
Yes, Your Honor. It is you. That is Kevin Pollard. Yes, Your Honor.
I'm Kevin Pollard.
You are Kevin Pollard today, Your Honor. I am the beneficiary.
And then who are you?
I am the beneficiary of the trust.
Okay, well then, Mr. Beneficiary, take you and your trust back to jail.
I have some questions for the clerk, Your Honor.
No.
I have. Can I speak to the clerk before we go any further?
You know what? I'll put you in timeout. Get your mind right. Mr. Pollard?
Yes, sir. Can I have the clerk present? Please, Your Honor.
Don't give in.
Please have the clerk present in a Zoom meeting.
You know what? If you answer my questions, I'll consider it.
Okay. What's your question?
What's your name?
Beneficiary.
All right, Mr. Beneficiary, put you back in time.
This judge is definitely taking charge now that we're back. Too many forgiving judges allow people to disrupt court without facing any repercussions, but this one isn't having it. Like a dad who has had enough of warnings, he is firm and direct. Acting out can result in your removal, or perhaps a brief jail sentence under the contempt of court laws. Courtrooms can become chaotic when judges fail to enforce this rule. I appreciate this judge's method since he is fair and stern. He gets a perfect score from me. He may be too harsh for others, but sometimes that's what's required. What are your thoughts? We'll see how the rest turns out.
I'm going to give you another chance in front of another magistrate.
That's no problem. Can I have the clerk present, please?
Hey, sir, I'm magistrate at Charter.
Excuse me? Yes.
I'm talking to the DDC officer.
Yes.
DDC?
Yes, ma'am.
Okay. The gentleman that is in front of the screen, in front of camera 1, what name do you have him listed as?
Kevin Pollard.
Do you have a middle name?
No, ma'am.
Okay, so you have a Kevin Pollard. Okay, and sir, you're identified as Kevin Pollard, but you're considering yourself the beneficiary. Is that correct, sir?
Are we on the record?
We are. Everything is on the record.
Okay. Are you stating that the trust that we are now administrating is the Kevin Pollard trust, ma'am?
I'm not administrating any trust because there's no trust in front of me. But what I'm asking you is, you call yourself the beneficiary. Is that correct?
Yes, Your Honor.
Okay, no problem. I have case number is 240-553-8101. People of the state of Michigan versus Kevin Theron Anthony Pollard, who
Your
is
Honor,
listed by DDC as Kevin Pollard. However, the gentleman has identified himself
Your Honor,
as the beneficiary.
you representing as Kevin Pollard today, Your Honor.
Mr.
Not me.
Pollard,
I'm not.
Mr. Pollard, now as your counsel, I am going to advise that you stop speaking and allow the judge to speak.
Yes, ma'am.
Counsel Kirkland.
Good afternoon, Your Honor.
Thank you.
Shava Kirkland on behalf of Mr. Pollard, who has been advised of his rights, which is to stand mute and waive the formal reading.
Thank you. I'm going to enter plea of not guilty. Court dates are February 2nd, 2024. It is a probable cause conference, followed by preliminary examination, February 8th, 1:30 p.m. Both matters are in front of Judge King.
I'm asking
Probable
a
cause
question.
conference, it is at 8:30 in the morning. Mr.
Your Honor.
Beneficiary, Mr.
You are on the
Beneficiary,
record.
you should not go into the court.
You
I
are
thank you
under
very
oath.
much.
You are under oath and you are on record. And I'm asking you,
Beneficiary, I have not sworn you under oath. I am under oath, so I am doing all this. I'm going to enter plea of not guilty. I already given the court dates while this case is pending, sir. Okay, there should be no
you are
contact
not allowed
with
to.
the individual.
You are not allowed to state what the judgment is. That is my
Mr.
job. Your
Pollard,
Honor.
Mr. Pollard, I do want to let you know that the person.
Okay.
I have a
All right,
question for the
you're not-
clerk.
Okay.
I have a
DDC
question for the
people
clerk.
for a moment.
I have a question for the clerk.
You will give an opportunity, sir. You will give an opportunity. Let me finish. The people, go ahead, Esteban.
Yeah, the people are asking for $250,000 cash bond, no cash, no surety. If he's able to ever post bond, we'd like GPS tethered with home arrest. The defendant, Your Honor, has a continuing situation where he entices young girls on the internet from Arizona in this particular case, and previously on 10/23/2023.
This individual need to be charged with contempt right away. He is openly disdaining the court, acting as though nothing is important, and disregarding the grave repercussions of his behavior. Even worse, he is providing a risky model for younger individuals who may not quite understand the consequences of their decisions. Even though everyone makes mistakes, his careless actions are negatively influencing other people. He faces allegations that might result in significant jail time. So this is not a little problem, and his actions are only making matters worse. Ultimately, he poses a risk to both the community and himself, and the possibility that he may return to the streets is worrisome.
2015, the 10/21/2023 case, where he was criminal sexual conduct first degree and also contributing alcohol to a minor, 2 counts of that, was at the exam dismissed without prejudice. In our particular case we have here today, Your Honor, the victim is from Arizona. She came here after having a relationship, not the victim, but one of the witnesses came here after having a 3-year relationship with this defendant on the internet. When she turned 18, she came to visit. And also, Mr. Pollard introduced her to another girl who is also from Arizona. The other girl brought her niece or her, I forgot the relationship, but her 7-year-old niece with her to visit Mr. Pollard. And what happened then, because the person was tired from traveling, she fell asleep. in the living room. When she woke up, she went into the bedroom, and there was Mr. Pollard with the 7-year-old girl. He then said, "What are you doing?" And he says, "Well, we're playing video games." So the woman, the adult in the room, she falls asleep again. And then she is awakened by the 7-year-old girl and asked to leave. The 7-year-old girl then tells her mother that the Mr. Pollard touched her, rubbed her, he says, okay? He said, accidentally is what he's trying to tell us what happened. The situation is she's told the 7-year-old child has told TED Talk that he did this. He's told Protective Services that he did this. And as far as I'm concerned, Judge, he fits the category of a predator because he did the same thing in the 10/23/2023 case of enticing young people from other parts of the country, perhaps, I don't know where exactly, to come and see him on the internet. So we're asking for $250,000 cash bond, no surety, and GPS tablet.
To be honest, even though the bond is high right now, it still seems excessively low for someone who has been accused of such heinous acts. Despite being called a predator and charged with unspeakable crimes, the bond sum is shockingly low. He is also blatantly making fun of the court, talking over the judge, and behaving as though he is above the law. For someone this violent and rude, I believe a bail of about $1 million would be far more appropriate. What are your thoughts? Should it be higher still? Let's return to the case and observe how everything develops.
I'd ask this court, understanding the seriousness of these charges, for a 10% bond if this court is not inclined to do a high personal bond. So one, I know the bulk of Brother Counsel's argument was this dismissed case from last year. I'd ask this court sentence him based on these allegations and the facts and details surrounding this case. This is a 2020 case, and the woman that he met was 20 years old, or that came to see him was a 20-year-old woman, was not an underage woman. And the allegation is that she brought her, I believe, goddaughter to the home. Now, there are different variations because a couple different stories are told as to what occurred there. But Mr. Pollard has maintained that he did not sexually assault the little girl. I'm not sure why this case wasn't charged until 2024, but it is a 4-year-old case. My understanding is that he, I don't believe he's had any convictions since then. He is a lifelong resident, has a child, so he has strong ties to the community. He also owns a lawn service here. At this point, there's no amount of bond that he can't afford to pay, so even a 10% bond would be unaffordable for him. But given the age of this case and his lack of issues since this, I'd ask this court consider a high personal bond, if not that, a 10% bond.
Thank you. I've heard the representations from both sides in this particular matter in reference to the beneficiary who is listed by the court or by DDC as Kevin Pollard. Is that in this particular matter, even though this is from 2020, okay, there was a forensic interview, Kids Talk, with the victim, and she disclosed that she was touched by the defendant and that he rubbed her with his hand. This court is not considering the other cases that were dismissed. They were dismissed without prejudice, okay? This court is only going with this matter. In reference to this gentleman, the defendant, bond is going to be $250,000 cash. There's going to be a GPS tether, home arrest. Further, okay, it's going to be unaffordable. So today is Friday. He's going to get another court date. Today's the 26th, January 29th, 2024, 9 o'clock in front of Judge McConicle, who's going to be looking at the bond amount and bond conditions. Also, there is one other thing. This court looks at clear and convincing evidence standard, okay, based on the representation, based on the reading. This court is convinced that Mr. Pollard, okay, I'm sorry, the beneficiary, okay, that he is a predator in this particular matter. That's why we're putting at $250,000 cash, GPS tether, house arrest. He does have the unaffordable bond redetermination for this Monday, January 29, 2024, 9 o'clock in front of Judge McConicle. Also, there's another bond condition. He's not to be around any minor children. That concludes the arraignment of the beneficiary, also known as Kevin Pollard. Madam Clerk.
Pretrial, Your
You
Honor.
wish
No, I was
talk
just
to the gentleman
Judge,
that's in
wait,
front of the screen.
Judge.
Okay.
Pretrial and
Just so
examination.
for the record, is that the clerk has declined to talk to the gentleman in front of the screen.
No, that is not fair.
Thank
That
you.
is not fair. You cannot do this. Under oath and on record, you cannot do this. I have rights, and you violated them, and you was not my judge.
Okay, you can go.
Is this unbelievable? This man seemed to believe that the judge would agree with his grievances, even though he is facing serious accusations involving minors. In actuality, the court has complete authority in this case, and the defendant has little chance of remaining free if he doesn't change his ways. He's attempting to negotiate his way out of this while facing the prospect of going to jail, which is almost ridiculous. His bond redetermination hearing is the main topic of discussion today. Things quickly grow heated as the judge rejects his request to reduce his $250,000 bond. Let's go right into the hearing and watch how this heated confrontation unfolds.
Somebody didn't appear at a hearing, it was reduced to the selling and furnishing of the alcohol. So he has an ongoing matter right now, Judge. He's on bond. We have this particular matter, allegedly, where this individual ended up touching a 6-year-old's. We have corroboration to that, Judge. And, Your Honor, with all due respect, the way that the people see this defendant, based on previously being charged, now being charged with another CSC first degree, we find him to be a predator. Not only that, Judge, we find him to be mentally unstable. He's currently on a case regarding minors. And just plain and simple, Judge, we find him to be a danger to the community. Therefore, Judge, we do feel as though a high cash bond is appropriate. We do feel as though the magistrate got it right here in terms of the $250,000 cash, not just to this particular complainant, but kids, all kids. This is one of those individuals where we feel as though he poses a danger to everybody.
See, where we I haven't heard their arguments of counsel. Where this gets a little dicey for concerning bond is that we have a situation where the defendant allegedly, I guess an 18-year-old comes in town to visit with him for her birthday. She turned 18, so she comes to see the 37-year-old. Who she's been in a long-term relationship with for the last 3 years. So I guess he would have been 34, starting the relationship with the year-old. Allegedly, she talks to a friend, and they come over, and the year-old is over. The girl comes and finds the two of them in the bed, and then the mother contacts the person asking who is this Kevin guy, because her daughter says he touched her. So, and then we have another case of furnishing alcohol to 2-year-olds, and whether there's sex there or not sex there, we have a pattern that's a little bit concerning. It's a lot of minors, a lot of alcohol, a lot of sex allegations, a lot of molestation allegations, a lot of flying people in who are kids and teenagers, and so we're real concerned about this. So the $250,000 bond is an unaffordable bond, and so the court does find that this defendant is a danger to all kids. He's just a danger. The court is going to disagree with the magistrate on this, and I know the magistrate or magistrates had some issues with this defendant, and they used the information that they had at this time to come up with the $250,000 bond. But the court does find that Mr. Pollard poses a great danger to the community, and a $250,000 bond is unaffordable, but it's not enough. It's not enough. So what we're going to do is we're going to add some to it to make sure he's incapacitated. But if he posts a bond, then that means we know that he'll appear for court. So the bond is going to be increased to $1 million, and that'll be $1 million